I apologize. Very glad to be the chair of this very special session. I found the article very, very interesting. So let me introduce our two speakers. Mira Siegelberg is no longer a PhD candidate in Harvard University department because I heard that she just submitted her dissertation. Mira's dissertation is titled The Question of Questions, An International History of Statelessness, 1921-1961, and it examines the evolution of the concept of statelessness in the 20th century and how it came to bear upon ideas of human right, international legal order, and sovereignty in the period after World War II. She has finished her PhD in the Harvard University Department of History, and she's a lecturer in the Social Studies and History and Literature program at Harvard. Mira studies the history of international political and legal thought, human rights, and humanitarianism. She holds a BA from Columbia University in History and Human Rights and received her MA from Harvard University in 2009. She was a graduate fellow at the Edmond Safra Center for Ethics.
The other one, yeah. The other one, right? There's one here.
Yes, the other one. It's not the other, it's the foundational one. Now we have it also here. 2011-2012, and is a graduate affiliate at the Minda de Ginsburg Center for European Studies. So welcome here. Our commentator is Tali Krichman Amir. She received her LLB from Tel Aviv University, magna cum laude, in the year 2002. She received her PhD also from Tel Aviv University and wrote her thesis on socio-economic refugees, 2008. So we understand why she's the commentator here. Tali was a Hauser Research Scholar at New York University School of Law and a Fox International Fellow at Yale University. From February 2010, Tali was also served as a Polonsky Fellow in the Van Leer Jerusalem Institute. She clerked for Justice Michel Cheshin in Israeli Supreme Court. And her main research and teaching interests are immigration law, refugee law, clinical education, labor law, and international law. So welcome both of you, and Mira.
Okay. So thanks so much for inviting me, to Eyal and Doreen, for organizing this wonderful conference. I've learned a lot from many of the people here before I came, and I've learned a lot since being here, so thank you very much. So my paper doesn't exactly consider the conceptual resources or the antecedents that might buttress, we might learn from to support the idea of sovereigns as trustees of humanity. But I've tried to provide a kind of sketch, because it covers a kind of long period, of a more recent genealogy of the concept of sovereignty as a normative idea, or an idea that we might sort of link to cosmopolitanism through a conceptual history of statelessness from the end of World War I to the period after World War II. So yesterday, Eyal described my paper in terms of the effectiveness concern as a kind of studying the history of a realist response to interwar idealism. And that's true. In my project, I've tried to understand the impact of the emergence of mass statelessness in the 20th century on ideas of international legal order and human rights. And so my big claim here is that the different nature, the different types of debates surrounding the problem of statelessness after the two world wars reveals the widespread liberal internationalist acceptance of sovereign statehood after World War II and its linkage in interesting ways to the idea of human rights. And so in some ways I'm trying to expand the group of realists, or to expand the definition of realism, who rejected the idea of a kind of supranational order for ensuring other regarding obligations, but also to look for the historical origins of a certain normative conception of statehood, let's say, distinct from ideas of national self-determination. And I wonder if there's sort of a historical story of the different forms of rationality that we heard from Sergio de la Valle earlier today. So as you saw in the paper, I've been quite struck by some recent work by Jeremy Waldron that looks at the idea that international law is really addressed to individuals rather than states, and that's really what we mean by, that's what validates international law today, and where one might look for the origins of that perspective. And some might argue that you should look for the period after World War II, and that's sort of the origin of a certain kind of humanity law. In this paper, I sort of question that perspective, and I look at the history of statelessness in order to understand the extent to which the reconceptualization of sovereignty after the Second World War, whether that actually lays the groundwork for this view of international legal order that you see in Waldron. I suggest that in order to comprehend the roots of this perspective, we shouldn't look to that moment. But I think it's valuable to consider the extent to which the revaluation of sovereignty on the part of legal scholars, particularly the sort of cosmopolitan legal scholars who had tried to disenchant the concept of sovereignty after World War I, and whether that might provide, if not an antecedent, but an interesting place to look for some of the origins of the idea of the sort of more normative conception of the state that we're talking about here. So the claim that the individual is kind of replacing the state as the ultimate unit of moral concern, people have different responses. It's exuberance, skepticism, trepidation. So although the idea that the principle gains more salience after World War II, it's a pretty widespread perspective, I actually think that if you look after World War I, the mechanisms of nationalization, passports, border control, restrictive labor markets, even though these were in place by the 1930s, there was sort of a sense that there were many different possible options for political organization. So just to kind of give a historical background, statelessness became a category of international legal analysis in sort of a widespread way and an object of humanitarian action after the First World War. The collapse of three major empires, the Russian Empire, the Ottoman Empire, and the Habsburg Empire, transformed the problem of people without any recognized state protection from an anomalous juridical condition to a central challenge for post-war order. Just to give you some sense of the scope, there were sort of 1.5 million people who fled the Russian Empire during or immediately after the Russian Revolution. By 1924, it was estimated that there were roughly 200,000 Armenian refugees dispersed in Central and Western Europe. And a controversial, the numbers of people in Central Europe who failed to kind of reclaim citizenship after World War I was sort of debated, but it was in the 100,000s. So it's important to emphasize the advent of masses of people in Europe and sort of the broader imperial sphere claiming not to have any protection was recognized as a kind of condition of catastrophe. But however curious it might seem, legal publicists across the Atlantic in the United States and England and across the continent treated mass statelessness as a key data point for central disciplinary questions and political aspirations. And the problem of statelessness became a constitutive part of theoretical debates about the future of global political organization and the nature of international legal order. And so it became a theoretical and practical humanitarian problem really at the same moment when theories of the state and the boundaries of political life were facing radical revision in the wake of imperial collapse in Europe and the Middle East. And Schmidt and Heller don't talk about statelessness, but it's a moment of kind of radically rethinking the meaning of sovereignty. It's not simply presumed that it sort of continues from before. We have to reconceptualize it, or the sense that we have to kind of reconceptualize it from the ground up occurs in a variety of texts and a variety of contexts. So grappling with statelessness rendered questions in political and imperial theory concrete in the European context. Questions about what it means to rule oneself, to rule others, the implications of legal membership without full citizenship, the sources of legal personality, all these issues run through the writings and debates of statelessness in this period, in the period after World War I. And so you could define the movement to dismantle the absolute power of the state as cosmopolitan in the sense that jurists were looking for ways to ensure that individuals were bound by some kind of legal order. It's not robust citizenship, it's the idea of having legal personality. And so in advocating for an expanded conception of international legal personality, and for the doctrine that individuals without citizenship could be the direct subjects of international law, legal scholars actually borrowed quite liberally from examples in the, quote, you could describe it as the kind of colonial sphere, mixed jurisdictions, legal pluralism. And And so they were looking for spaces in which divided forms of sovereignty and overlapping jurisdictions could provide a model for reconstructing politics after the war. The establishment of new forms of international administration after World War I also lent credibility to the idea that non-state entities, including individuals, could also be sort of direct subjects of international legal order, sort of in the 19th century positivist doctrine, which is also kind of being codified at the same time. The jurists kind of continually assert that it's only states that can be subjects of international law. So just to give an example, the League of Nations had a mandate to directly administer the free city of Danzig and to kind of adjudicate disputes there. The Permanent Mandates Commission, obviously very well known here, advised the council. So there were sort of different kinds of political institutions being set up that allowed legal scholars who were kind of looking for ways to situate individuals within this legal order. It provided evidence that they were there. It was on the horizon. And so they applied these theories to the idea of statelessness, and particularly to the question of whether statelessness could answer the question of whether individuals had personality outside of sort of state authority or the state granting legal personality. One scholar in 1929, Jean Spiropoulos, said that the question of the position of the individual in international life was the most discussed problem of the profession. And in another text, Herbert Glucksmann said that that's why statelessness was really the crux of international law. So I'll just note here, I talk about it in the larger work, but not in this paper. Debates about paternalism and trusteeship, you could say, come up at around these issues, and in a similar fashion from the way we've been talking about them at the conference. Some people wanted more forms of international administration to protect newly vulnerable populations, newly vulnerable people, but there were many counter arguments and worries that international forms of administration would be a dangerous form of control, beneficence, but also discretionary power. But I think it's only really through the recovery of this interwar moment that we can set the treatment of statelessness in the period after World War II in clear relief, and identify the ways in which the concept of supranational legal order transformed over the period of the two world wars. Because by the 1950s, statelessness no longer served as a key reference point for theorists of international legal order, and instead it was replaced by a more humanitarian framework that no longer touched on the fundamental legitimacy of national sovereignty, and hence the power to determine who qualified to enter or remain inside the political community. And so once we view the period after World War I as a kind of testing ground for forms of international governance, rather than a weak prelude before kind of the rise of human rights in the post-war era, we can see that the figures who were centrally involved in theorizing and building up international administration after World War II, some of them tried to kind of continue implementing interwar dreams or to kind of reimagine human rights as a continuation of the promise of the interwar period, but many thought that they were correcting mistakes they had made in the past or were resigned to the hopes that they had just never coming to pass. And here I wonder if whether the post-war period was really Heller's moment. Hermann Heller died, and many more people sort of turned to a conception of sovereignty that they had rejected in the interwar period. So a number of scholars theorizing the future of democracy during and after World War II presented the war as a referendum on the kind of pluralism and the pluralist theory of the state that they had sort of entertained earlier. And the topic of statelessness, whose intellectual fortunes were tightly tied to the concept of legal order in the interwar period, now seemed subject to the same forces and to have lost its prior significance. In the paper I quote Mark Vishniak, very interesting Russian Jewish emigre jurist who wrote quite a bit and advocated for stateless, mostly Russian emigres in the interwar period, described statelessness as this kind of pathogen that could reveal the anatomy of the state. This is in 1933. But after he emigrated to the United States and continued writing about statelessness, he sort of bemoaned that it lost its powerful interpretive and heuristic significance. International lawyers no longer talked about statelessness as a kind of way to understand the nature of sovereignty. Hirsch Lauterpacht is perhaps most associated with the turn to individual human rights in the post-war era, and famously argued in a well-known article, The Grotian Tradition in International Law from 1946, that the individual is the ultimate unit of all law. But if you actually look at the role he played in sort of debates from the 30s and 40s about human rights, and particularly about the importance of the right to a nationality, the right to a state, he plays a slightly different role than he's usually cast. So, I mean, he really he thought about statelessness as a way to argue for a more pragmatic approach to the question of who or what were the proper subjects of international legal order. Most of the lawyers who participated in wartime meetings agreed that the emphasis should no longer be on the power of international society to assure an individual's rights or legal personality. I mean, some claim that human rights represented, and eventually the Universal Declaration represented kind of the culmination of their interwar dreams. Okay, just checking. So if we jump forward a little bit in time, and look at some of the correspondence, for instance, between the legal advisors developing the 1961 UN Convention on the Reduction of Statelessness, it really highlights the way the symbolic states of statelessness decline for cosmopolitan lawyers. So Lauterpacht urged his student Paul Weiss, who became the head of the International Refugee Organization, not to be too worried about kind of expanding the authority and expanding the power of an international organization, to no longer be concerned about the idea that an institution could provide a kind of legal counterweight to the state, and just to focus on sort of the practicalities of helping refugees and helping the stateless. So he said, for example, I mean, he was actually concerned that statelessness the convention could saddle states with a large number of people who would be obliged to nationalize. And he suggested that the convention requires signatories to confer nationality on stateless persons that had been resident in a territory for 10 years. So it's really quite different from arguments from the 20s and 30s about domicile and sort of the automatic granting of nationality just on the basis of being present on a territory. Paul Weiss actually described the convention as a realist. I mean, he used the term, he said it's a realist solution, and that he no longer held out the hope that there would be a kind of international nationality for the stateless. So when the idea that individuals rather than states were subjects of international legal order became part of the project of post-war, meaning post-World War II reconstruction, I think it meant something quite different from what it had meant before, at least for the legal scholars who had held out hope for this possibility at an earlier date. And the idea of human rights after World War II was connected with the revaluation of sovereignty, rather than with the idea of individuals as legal agents, totally separate and free-floating from particular political entities. And so I think there still is an important distinction between the legalist ideology and that of kind of the Morgenthau, Schmittian realist, but I think the line is a bit blurry. Taken as a whole, the debates among cosmopolitan international legal scholars indicates the extent to which the post-World War II moment was understood as a realist response to interwar idealism. Legal scholars who remain committed to the project of international law newly asserted the state and the right to a nationality as the basis for legal personality. And so what do these episodes tell us, if anything, about antecedents for concept of sovereigns as trustees of humanity? So Eyal has suggested that there is a moral need to reconceptualize sovereignty in a manner that would oblige states to take other regarding considerations seriously when forming their national policies. And I think it's interesting, and I might not be reading this correctly, but I take it that it's not based on international law, but rather on a different conception, on the idea that individuals precede the state due to their inherent dignity. And I think that shift is interesting because in a different decade it might have been couched in a different discourse. The novelty of this idea lies in its departure, possibly, from the view of law and international legal order as the means to gently civilize states. Post-World War I legal cosmopolitan was part of a much bigger assault on the concept of sovereign authority that was really reconstituted or rebuilt, or maybe made completely new. I mean, that's recently historians have been arguing that, you know, the history of the state really starts after World War II, but we can argue about that. And after the war, liberal political theorists across a wide spectrum tried to correct the prior emphasis on pluralism and newly emphasize the importance of state citizenship. They accepted the idea that states remained the primary basis for international law and its main addressee. And I think recovering this context suggested the pragmatic, maybe deformalized definition of international law directed toward the improvement of individual lives that Jeremy Waldron talks about can't really be traced to this post-World War II moment. I mean, maybe in a limited way, but its historical origins belong somewhere else. And instead, I think it might help us explain the turn towards the moralization of the state in the 20th century and provide a historical precedent for normative conceptions of statehood and maybe states as agents of moral responsibility rather than as political entities that need to be kind of governed and tamed. I'll stop there. Look forward to your comments.